Good morning, everyone, and welcome to what is the second in a series of 3 webinars this autumn, organised by the 3PB Barristers Corporate Protection team. My name is Matthew Gullick, and I'm the head of the Public and Regulatory Law Group here at 3PB Barristers. I'll be chairing today's webinar, which will look at the corporate protection from the particular perspective of the discipline of psychiatry. It's great to be able to welcome again so many of you from all across the country and from a diverse range of professional backgrounds, including clinicians, lawyers in private practice, those working in social care, NHS trusts and local authorities, to what we hope will be another very interesting and informative session. And as those who attended the first webinar will recall, given the multidisciplinary nature of practice in relation to matters the Court of Protection deals with, we very deliberately tried to avoid giving a purely legal perspective, because we hope that by sharing knowledge and ideas in this series of webinars, we'll promote collaboration in working, which will ultimately be for the benefit of patients and service users. And we're very grateful for the feedback we received after last month's session on the Court of Protection and geriatrics. The final webinar in our series will be on Tuesday, the 12th of November next month, also for 1 hour at 12 o'clock. Which will be a health and welfare case law update given by Jim Hirschman and Matthew Wyard of 3PB Barristers, chaired this time not by me, but by His Honour Stephen Wildblood, King's Counsel, who recently joined 3PB as an associate member following his retirement as the senior family judge in Bristol. You can see more details about that session and register to attend it if you haven't already done so in the events and seminars section of our website at www.3pb.co.uk. And if you have any queries in relation to that, then please do email us at response@3pb.co.uk. The PowerPoint slides for today's webinar will be emailed to you after the conclusion of the talk. We hope later this afternoon, but if for any reason you haven't received the slides in the next couple of days and would like to have them, then please do get in touch. Our speakers for today's webinar are Nicola Taylor and Matthew Wyard. Nicola Taylor is a consultant in liaison psychiatry at University Hospitals Bristol and Weston NHS Foundation Trust. In that role, she works with a team of practitioners to support the mental health needs of patients within the hospital and its outpatient departments. Her work and that of her team involves people who are often very unwell and where decision-making can be time critical. Nicola is also a senior tutor at Bristol Medical School, and we're delighted that she has agreed to share her knowledge and experience with us this morning. Matthew Wyard is a barrister at 3PB Barristers, specialising in public law with a focus on healthcare and court protection work, including medical treatment disputes. He is chair of the Court of Protection Practitioners Association's West Midlands branch and is ranked in the Legal 500 directory for court of protection work. Today's session will be delivered slightly differently to our first session as an in-conversation session between Nicola and Matthew. They will look at best practice for lawyers and psychiatrists when working together, including requirements in relation to expert evidence, moving on to look in detail at medical treatment in the field of obstetrics, including looking at some of the decided cases in this area, including best interest considerations, abortion and contraception. At the end of the discussion, they will compare and contrast the approach in this context under the Mental Capacity Act, that under the Mental Health Act. The presentation from Matthew and Nicola is going to last around 40 to 45 minutes, following which there'll be a question and answer session of around 10 to 15 minutes, and finishing, we hope, at around 1 p.m. If you do want to ask a question, then please type it into the Q&A box on your screen as we go along. You don't need to wait until the conclusion of the talks, and if you do wait until the very end, then we may not have time to answer your questions. So please, if you have a question, you can put it into the Q&A box as you go along. The questions typed into that box will only be seen by the panelists, not by everyone attending, and your name will not be read out with the question. So please use the Q&A box, not the chat box for questions. Anything you put in the chat box may, depending on the option you select when putting it in, be seen by other attendees. So please use the chat box for administrative questions and the like, but not for questions and answers. And I'm now going to hand over to Nicola and in the first instance to Matthew to begin today's talk.
Thank you for that introduction, Matthew, and thank you, Nicola, for joining us. We'll come to you very shortly, as you know, but we thought when we were preparing this webinar that the best place to start, seeing as it's a collaborative exercise between clinicians and lawyers would be to set the legal framework out in respect of expert evidence. We know that there are some clinicians on the call, some who may have given expert evidence in the past in the Court of Protection, some who may not. So we thought as a starting point, it would be good to outline what the court's requirements are for expert evidence. And really, the starting point and the first thing that you need to know is that in the Court of Protection, there are two kinds of expert reports. Something that we'll hear referred to as a Section 49 report, and alternatively a Part 15 expert report. The key difference from a clinical perspective is twofold. One, a Section 49 report has to be completed within the course of your normal day-to-day practice, i.e., if you're an NHS doctor, it will routinely be part of your NHS practice to complete, and therefore the costs of that are paid not directly to you, whereas if you're a Part 15 expert, then you are doing it in private practice and you can charge a fee for preparing the report. And because of that, point number two is that a Part 15 expert report is what you might think of as a traditional expert report. It's a standalone report that considers one particular issue. In the COP context, for instance, it might be something we'll talk about later, someone's capacity to make a decision on the mode of delivery of a child. A Section 49 report typically and should only be being used where a particular patient is already known to an NHS trust, and the idea being that the report can be prepared relatively quickly because the clinician preparing it should already know the patient. The lawyers on the call will appreciate that that's not always the case, but that is in theory the two key differences. And we're not going to focus on Section 49 reports today for the purpose of this talk. It's on Part 15 experts. What then, when you prepare a Part 15 expert report, should you be doing? Well, as a clinician, the starting point is your duty as an expert. And that, as you might gather from the name, a Part 15 expert report, is set out in Part 15 of the Court of Protection rules, supplemented by Practice Direction 15. And what Rule 15.4 explains is it's the duty of the expert to assist the court on matters within the expert's expertise, and that duty overrides any obligations to the person from whom the expert has received instructions or from whom they are being paid. Now, that's supplemented, as I say, by Practice Direction 15A, which confirms that an expert should assist the court by providing objective, unbiased opinion and should not assume the role of an advocate. And in doing so, the expert should consider all material facts, including those which might detract from their opinion. So, summarising that in a nutshell, if you are acting as an expert, your role is to answer the question that you have been asked by the parties, but giving that answer to the court. And it's designed to assist the court make the decision in relation to that particular question. You should be answering that objectively and fairly, and you shouldn't, although it does occasionally happen, be trying to argue one side of the case or the other. You should simply be giving your professional view. How should you do that? Well, the practice direction does give an indication of the form and content of an expert report, and it sets out a number of matters that you should include. Firstly, what your qualifications are, and details of the material that you've considered. So, who you are, and the documents typically that you've been provided by the instructing party in the case. That can be, and we'll come on to this when we talk to Nicola, things like GP summaries, clinical records, previous capacity assessments, anything that can give an insight into someone's state of mind and ability to make a decision. You should then, as an expert, be setting out the substance of the facts and the instructions that you've been given, and make clear which facts, when you are talking about them in your report, are ones that you have ascertained yourself, most likely through an interview with the patient, and those that you've gleaned from the reports that you've been sent. If as an expert you want to carry out an examination or an assessment or a test on P, then you need to explain that you've done so. If you commission one, or it's conducted by a colleague or an assistant, then you need to explain who that person is, their qualifications, and whether you supervise them. Now, what's not unusual in cases in the Court of Protection is that when someone has conducted an assessment, there can be a range of opinions and a range of potential options for the court to consider. So when we come on to look at obstetric cases, and we're looking at the mode of delivery, one option might be that someone has capacity to decide to give birth naturally, or it might be a cesarean. If there are various options, you need to set those out and explain what your reasons are for your own view, and then give a summary of your conclusions. Your report needs to be detailed enough to answer the question that's been asked, but preferably not so detailed and so lengthy that it overwhelms the court and the parties. And importantly, your report must contain a statement of truth, which is on this slide, and is in effect a statement confirming that you understand that your expert duty is to the court. So that, from a legal perspective, is what an expert report should look like. We'll now turn to Nicola, who's going to explain from a psychiatrist's perspective her views on psychiatrists and lawyers working together. Over to you, Nicola.
Thank you so much. I love that description. There's often a range of opinions, and there's an old joke about psychiatrists that if you put 3 of us in front of a patient, you'll come up with 4 different diagnoses. And there's a reason for that, and that is because our specialty works with the single most complicated kilogram of matter in the universe, the human brain, with 100 trillion chemical switches held together with electrical wires, and it is the sum of a person's experience, not just their genes, but their upbringing, their culture, every grief, every hope, every job lost, every job found, every aspiration, all together in this incredibly complex system that we only have a tiny insight into, and it changes with time, all the time. All of which to say is, and I usually hate saying this because often we say it's complicated when we mean it's just difficult and we don't like the decision we make, but the human brain, humans, people, are really, really, really complicated. And that's why sometimes in psychiatry you can seem to have such a diverse range of opinions about what is going on for someone. We were talking, Matthew, earlier, you and I, about what would be helpful from a psychiatrist's point of view for solicitors and barristers and the legal profession to know. And one of them is, we're not very good about predicting the future with certainty. I work in a city centre hospital and I work in ED a lot over the years, and I've seen thousands of people who tell me that they want to end their life. And that means that I'm probably, the evidence says, I'm probably the best predictor of who's going to go on and do it, and I am not very good at it, because it's really difficult to predict what's going to happen in such a complex system with constant interference from, the rest of the world. So people assume that psychiatrists can predict the future, but I promise we can't. Some of my forensic colleagues are probably better at doing it when they're using tools and standardized protocols, and they've had months, sometimes years, to get to know somebody in every aspect about their past. But usually we're not very good about predicting the future. And we can say that one of the best predictors of future behaviour is past behaviour, but actually putting timelines on it, or seeing even how people are going to react to medication or therapy, it's enormously difficult to do that with certainty. I think the other thing about psychiatrists is we're doctors, and we went to medical school and had an interview, and they said, why do you want to be a doctor? And 9 out of 10 of us said, because we want to help people. We want to help people. And you're one of the people we want to help. So unless you're speaking to somebody who often acts as an expert witness, we are going to want to help you answer your questions. Sometimes, whether it's within our expertise or not, we will want to try and be helpful to the person in front of us. So that's obviously our responsibility to say, I can't answer this question. But please, from your point of view, bear that in mind as well, that we want to be helpful, and sometimes you're going to have to stop us being too helpful, because ultimately it's not going to be useful. I've also was reflecting on some of the conversations I had with solicitors and barristers and various trusts over the years. And what struck me is how different we are in the language that we use and what we're talking about. Because as a doctor, I want to tell you all of the things that I've done and everything that I think about this person. I want to convince you that I'm giving the best quality of care I know how to this person, that I've done it in the kindest and most compassionate way. Whereas sometimes the lawyer that's sitting on the other side of the table just wants to ask one specific question about a point of law. And when I hear that, I say, no, you've not understood how difficult this is or how complicated this is, or I want to tell you more about it. And so sometimes, from your point of view, it might be useful to remind us that you're not necessarily questioning the quality or the amount of our care, but just that you're asking from a different prism, a question which seems irrelevant to us, but will have all the importance in the world for you and the Court of Protection. But because we're looking at it from a different point of view, then it doesn't occur to us. And the last thing that I was thinking about was dialogue. I can't remember the last time I spoke to someone from the legal profession in a professional capacity where it wasn't a crisis. 4 o'clock on a Friday, or something had to be done, a decision had to be made within an hour or a couple of hours, or there was some drama happening somewhere, and nobody's ever at their best in a crisis. So one of the things that I've learned over the years is to try and maintain a dialogue or a conversation with the solicitors that I work with most closely, so that they can understand me a little bit in my specialty and my team and where I come from, and I can understand them, so we can work together to have the best outcome from our patients and our patients' families. And the only other thing that I was reflecting on is that I suspect that when lawyers look through our medical notes, they say, why couldn't have we predicted this outcome sooner? Why couldn't we have predicted that this was going to be difficult? Why couldn't we have predicted that this was going to end in a worsening of somebody's health or even their death? Why couldn't we have predicted it? Because it was written through the notes all the time. And all I would say is that's written in lots of people's notes all the time. And it is enormously difficult trying to pick up from this ocean of information the patients' families who are going to be faced with difficult dilemmas that will actually reach the Court of Protection or have these really difficult, often crisis-driven conversations. But it appears easy to predict in retrospect, but I promise you that at the time it is not easy to predict. Some reflections on psychiatrists and lawyers and how we speak two different languages, sometimes coming at one problem from two different prisms.
It's interesting, isn't it? I mean, the point on expertise. So what is then, would you say, is a fair expertise to assume that a psychiatrist has? Because I was reading, and obviously in our pre-webinar discussions, one of the interesting things we were discussing was an article in the Medical Law Review that makes the case that psychiatrists are used more in any other area in the COP than anything else. Yet we as lawyers seem to assume that you have the expertise to comment on any domain of capacity. What are your thoughts on that?
I think that different psychiatry subspecialisms will probably have different areas of specific expertise. I think that I could probably comment on somebody's capacity to accept psychiatric treatment in the confines of the acute hospital, or to accept physiotherapy if they have a functional neurological disorder, because those are my areas that I deal with all the time. I think that I could probably be helpful to my physician and surgical colleagues when they're assessing the capacity. They have all the information about the risks and benefits, but I could probably talk about whether somebody's mental disorder is impacting on their ability to use and weigh that information to try to come to some sort of capable conclusion. I would be less useful describing or trying to assess the capacity of somebody for long-term, even depot antipsychotics, just because that's not what I am used to, even though it falls within the scope of being a psychiatrist. I would certainly have difficulty speaking about people with intellectual disabilities of any sort of profundity, because that's just not what I'm used to dealing with. So we have these different specialties. I think when it comes to things like, can this person manage at home? Can they choose their care home? Can they we want to profess opinions because we often know the patients, we want what's best for them, but I don't think that means that it necessarily falls within our scope of expertise, and we'd be better speaking to the physiotherapists, the occupational therapists and the social workers. But it falls back to, we want to be helpful so badly, we sometimes forget that we're not ultimately the decision maker in that decision.
Is interesting, and the point you make about when you speak to lawyers, it's always a crisis situation. Do you find that that's driven by the lawyer or the clinician? Because in theory, the lawyers get involved. We should be helping you, particularly in the COP. If you're representing a trust, you're usually going to the COP asking it to make a declaration that the treatment you want to deliver is lawful. So presumably, it's a crisis is driven by the clinicians, or is it driven by the lawyers?
No, I think it's. I think I'll take this one. I think it's driven by clinicians. I think a lot of the time, we're hoping that things will fall out and will come into place and be kind and compassionate and fair, and everyone will agree, and patients will agree, and their families will agree. And then there comes a crunch point where we think, well, we're not sure where to go with this, and we need some legal help to make sure that we're doing everything right. We might need some help from the Court of Protection. But I think it's also, and this is no reflection on them, I think it's also driven by patients, because patients are people and they change their mind horrifically, and they don't always play our game because it's not their game. So the patient's perspective as well is one which isn't necessarily shared by their doctors, the psychiatrists or the lawyers, but it's the one that's at the heart of it, and they get to change their mind, they get to change their views. And the nature of healthcare, as well as sometimes things happen quickly. Even if we think we could have predicted them for a long while, they happen quickly. And it's 4 o'clock on a Friday and I'm on the phone to somebody saying, we need some help in trying to sort this out.
And then from a legal perspective, because we do have clinicians on the call, it's probably useful to set out, well, you tell me, Nicola, maybe it's useful to set out what our view is as well. So I think you're right about the limits of expertise. And the one thing that I would say is it's always worth asking. Would you agree with that? If you've got a psych and you're not sure if they do have the limit of expertise, presumably no one's going to complain if you ask them.
Well, no, we get asked much more difficult questions than that, I think, all the time. So please start that conversation and dialogue to check, are you sure that you've had experience in this and this is within your remit?
Then the plea from me, which I think is a fair plea from all lawyers, when you're, as a clinician, thinking about the timeframes that you're going to complete things in, I mean, the one thing I would say that has happened to me a lot over the years is you have a deadline set by the court. It's not usually set by the lawyers, although it can sometimes be. And then you have clinicians who are extremely busy, undeniably, always constantly busy. And understandably, as you say, you're interested in caring for patients. You're not necessarily interested in writing the expert report for the court for the patient. So the plea from the legal side, I suppose, is where you have a expert report to do. If you can't do it within the timeframes, please tell us early. It's really no, knowing 3 days before the deadline does cause the lawyers a bit of a crisis.
Yes, I mean, and it is fun to keep you on your toes, obviously, but I think it's another fallout of doctors want to say yes, generally say, I can get that done, even if it's delusionally optimistic, So I'll take that back to my people as well.
And documents tell us if you need to see things, let us know. I mean, in theory, lawyers should be quite good at predicting what you should want to see. But I mean, what out of interest, if you are assessing someone's capacity, what are the key documents that you would want to see as a psychiatrist?
I would want to see what information has been given to them. I'd want to see their progress through the medical notes while they've been in hospital, which is where all my patients tend to be. And then I would probably want to have an actual discussion with a clinician. I'm thinking of specifically in terms of where people are being consented for surgical operations or medication, but it's the discussions around it that we have are actually really quite difficult to articulate and put down in medical notes. So I would want to have that discussion with the physician and the surgeon, with the patient there in front of them, so I know what's being said. I think Information is also difficult to get because in any given patient, and I will use the word journey, there will be GP records which we may or may not be able to get, psychiatry records which we may or may not be able to get, non-stat services records which we may or may not be able to get, social services records, as well as the acute trust records, all of which will be held in different ways, none of which will speak to each other, and all of which will be filed in such a way that it's incredibly difficult to know that you've seen everything that you need to know. So there has to be a balance between it, because there's just so much documentation in people's files now that everything is kept. So it's incredibly difficult to know that you've seen everything. Almost impossible, I should imagine.
Yeah, I suspect that's probably right. Should we talk about obstetrics? What on earth is obstetrics? You tell us. You're the doctor.
Well, I think if you looked up Wikipedia, obstetrics would be described as a medical specialty that's involved in childbirth, pregnancy, childbirth, and the postpartum period. But if I asked one of my obstetric consultant colleagues, they might describe it as the whole of medicine minus paediatrics, but more complicated and a constantly dynamic situation with a time limit at the end of it. So it's like the whole of the medical practice, but condensed and made more complex, and everybody wants to be involved.
Thank you for that. So what we thought, Nicola and I, that we would do is talk through, because we've noticed that there is undeniably an enormous increase in the volume of medical treatment decisions going to the Court of Protection, and a lot of them, if you look at the recent decisions list on Bailey, do concern obstetric care. So we thought we'd talk about the breadth of decisions involved, the relevant information that's required for various decisions, the best interests considerations, as well as, from Nicola's perspective, the practical considerations that apply. And I know you're not an obstetrician, Nicola, but my understanding is that this is an interest of yours.
Yeah. Yes, I'm often in discussion with the obstetricians.
So I'll talk about the law and then we'll come back to you if that's okay, Nicola. I'm sorry. We've got to talk about it at some point. So the key case then on capacity to have the ability to decide on mode of delivery is Re D from 2014. The facts are similar to sadly a lot of obstetric cases. It was about a 36-year-old lady who had various conditions, autism, borderline learning disability, and at one point in time had been diagnosed with delusional disorder. And at the time of the hearing, she was pregnant with her 6th child. 4 children had been adopted, and the 5th, was with a permanent substitute carer. And the trust in this case was seeking a declaration as to the lawfulness of arranging for the delivery of her baby via caesarean section. It's an important point to note is that whenever, as a trust or a solicitor representing the trust, hopefully you will appreciate that what you should be seeking is a declaration for the positive clinical act that you want to carry out. In this case, as I say, the trust was seeking a declaration as to the lawfulness of arranging for delivery via caesarean, and there were 4 potential birthing options for the court to consider. So a spontaneous vaginal birth, an induced vaginal birth in hospital, a vaginal birth at home, or a caesarean. And from the quote on the screen, this was recorded in the court's introduction. We can see the level of invasion of privacy as well as the steps that the trust wanted to take. So in effect, the trust wanted to be able to access, if they were to have permission to do the caesarean, access P's home by force if necessary, remove her to hospital, give her general anaesthetic, and then conduct the procedure. Obviously an extremely difficult and tricky situation to be in. But what happened in Re D was interesting because the court noted 3 generally important points that would arise in any mode of delivery case. Firstly, that when considering best interests, and we'll come on to talk about this in more detail, it is in, according to the court, the best interests of any woman carrying a full-term child whom she wants to be born alive and healthy, that such a result should, if possible, be achieved. Now, I wondered, Nicola, what your thoughts on that were. You may not have any, but
Well, I was reflecting on one of the cases that I might talk about in a little bit, where in obstetrics and in psychiatry and medicine, we tend to put the interests of the women carrying the birth above the interests of the unborn child or fetus, or however you want to describe it. But of course, that's not the same weight that's given by the person who's pregnant. And so I was recalling one of our patients who wanted to continue to carry her pregnancy to term, even at the risk of her own death. And the capacity question that came into that, but I can maybe come back to when we're comparing a couple of cases in a second.
Okay. The second point was that the court doesn't have jurisdiction to take into account the interests of the unborn child, and as with any decision in the Court of Protection, must have regard to the least restrictive option. And it went on to identify, in a very concise list, helpfully, 8 points of relevant information that need to be understood, used, weighed, communicated, and retained in order for someone to have capacity to make a decision on mode of delivery. Those 8 points, just running through them, are the antenatal monitoring of the mother, the antenatal monitoring of the fetus and value of ultrasound, the various potential modes of delivery of the child, the difference between natural and induced labour, anaesthesia and pain relief, the various places of delivery and the risks and benefits of each option, the risks of complications arising from conditions, and the postnatal care of mother and child. And what struck me as interesting when reading through the authorities is that we can compare that directly, because of North Bristol NHS Foundation Trust and R, with the relevant information that someone has to take into account when the only safe clinical option is caesarean. So in North Bristol, it involved a 32-year-old detained prisoner. No one seemed to know how she'd fallen pregnant, but she'd had 2 previous children removed. One was adopted and one was placed on a full-time basis with her mother. She was admitted to hospital because she had a growth-restricted baby. So obviously a very potentially significant and serious situation. And her condition by the time of the hearing had deteriorated to the point that a consultant obstetrician determined that the only safe delivery option was a caesarean. And the court had to look at that and determine what the relevant information that P needed to know to have capacity was. That was slightly less, that was only 7 points, but they were why the doctor wanted to perform the caesarean, or in other words, the clinical imperative in that case, what the alternative options were, what the procedure itself involved, whether it was safe for P to have that procedure, the safety for the unborn child, the recovery period, and the consequences of removal. And something that I found really interesting was that those 7 points of relevant information are not, if you compare it with the Royal College of Gynecologists and Obstetricians consent guidance, they are not the same pieces of relevant information. And it shows that, I think, interestingly, where we're looking at someone who lacks capacity to make a decision, then the relevant information is not always, it reminds us that it's not always the same as it is for someone who has capacity, although often the court will try to suggest that it is. What then if someone lacks capacity about best interests? Well, the really interesting one, and there are many best interests considerations that apply, but the most interesting one I thought was the role of the child in best interests considerations. And the key point being the court can't actually take the rights of the unborn child into account. That comes from 2 cases. First, an old case from 1979, Patton, and the British Pregnancy Advisory Service, which is a case that many will remember from, if they've studied medical law, the case that confirmed that a fetus does not have legal rights. And that case, as well as many others, were considered by the Court of Appeal in Re MB in 1997, in which the court confirmed there, that was obviously pre-Mental Capacity Act, but under the old system, that the court couldn't take into account the rights of an unborn child when considering its mother. And then we have to compare that, which what I think is interesting, with the case of Guy and St Thomas's Trust, which said that it will be rarely the case that P's best interests will be promoted by permitting the death of or brain injury to an otherwise viable and healthy fetus. So on the one hand, we can't take into account the rights of the unborn child, but on the other hand, there is almost, I mean, it's not an assumption, but it's almost there, if it's rarely the case, almost an assumption that P's best interests are not served if the fetus passes away during birth. But I think that's probably a nice time, Nicola, to come to you for your practical examples. And I know the one that we did consider beforehand, that we both found interesting, was the timeliness issue, because the courts will often say, well, you've had 9 months to consider this. Why on earth have you only come to the court the day before or during the time when we need to make a decision? I wonder what your thoughts were on that, Nicola.
Yeah, well, the case that we were talking about, I think, was brought was the best dinner party interruption ever, where the trust solicitor phoned me one evening and said, Dr. Taylor, this is not the last time we will speak tonight. And I thought, well, I'll pop away the glass of wine. This is going to require some attention. And this was a young woman who was 32, who had a diagnosis of schizophrenia and had some intellectual disability and was 8 and a bit months pregnant. And the social services were also planning to apply to be able to move the child at birth. So there was a lot of sadness and kind of tragedy around this. And my trust had already gone to court, but the judge sitting and hearing it had asked for more detailed care plans, which prompted the phone call that night to me, because she was going to plan to be delivered in our hospital up at St Michael's. And what took place over the next few days, a week or so, was a series of meetings with a lot of different people, including the obstetricians, the anaesthetists, the community psychiatrist, the ambulance service, the liaison psychiatrist, all trying to work out how we were going to consistently test the capacity of our patient from the point of labour starting to a safe delivery in our postpartum care. And that meant that we had to devise a lot of care plans, where at every point we had to identify the question we needed to ask. Will she be able to recognise labour? What's she going to do when she recognises labour, if she recognises it? If she doesn't, is she capable? What's going to be in her best interest? Who's going to be there to do this? What happens if she doesn't want to get in the ambulance? Is she capable? What's going to be in her best interest? And trying to predict, like a decision tree, every possible outcome of this really complicated journey, not even a metaphor, it was a complicated journey from her house up to St Michael's. Happily, the pregnancy was reasonably safe, except that it was breech. And there was a question about caesarean sections and would we be able to do that? Our patient was open to the idea of a caesarean section. And it brought home to me the number of decisions we ask people, patients, women to make in childbirth in this example. The number of times that we question their capacity less when they agree with us and more when they disagree with us, which comes back to your point about how much information we give people to make decisions and what the recommendations are, and how difficult it can be to try and get everybody to agree about the timeliness and practicality of whatever options we're going to use, because there has to be a practical element to it. Do we have an ambulance that we can get in the back of? Do we have enough paramedics? Would they use restraint? Can we give her sedation? Who would be there to prescribe it? All of these questions that we needed to have answers to, because a judge was critical not only of our initial foray into care planning for this case, but also the timeliness. And he said exactly what you said, why are we waiting till the 8th month? And I think the truth is that there's going to be lots of patients, women who have mental health disorders and possibly intellectual disabilities, and we don't have to think about this complex question of capacity because they kind of agree with us, or we say, you're capable, people, and we're always living in hope that something's going to be helpful. The family will help bring them round, or we can build a trusting relationship with them, or something will happen that will make this all simple. So we often wait till the last moment, because if we care plan for everyone to whom it could happen, we'd be doing nothing else except emailing you. But the coda for all of this work is that we managed to bring this patient up. The community team did a fantastic job of reinforcing their therapeutic relationship. We managed to bring her up. We brought her into hospital. She actually, the baby had turned at the last moment, thank goodness. She had a normal vaginal delivery, and because the baby was being removed at birth, then the baby went to one of our special care baby units, and we looked after our patient. We restarted her all the antipsychotics that we had changed during her pregnancy, and we arranged an inpatient unit stay, taking care of the postpartum period, because we expected there might be problems then. And everything was okay. Everything was okay. And indeed, the last time that I saw her, said goodbye to her, because we'd spent some time together in hospital, and the last thing she asked me to do was go to the special care baby unit to give her baby a cuddle, because she wasn't going to be able to, but she looked forward to in the future. And indeed, we managed to get her community managed to get her contact back with her baby to have some part in his life, even if it wasn't as the primary caregiver. So all of this complexity, often in really tragic circumstances, but can, I promise, work out beautifully every so often.
That's good to know. So the other area that's interesting is contraception, and the key case that people need to know regarding capacity to decide to have contraception, to take contraception, is a local authority and that confirms really two key things. Firstly, that contraception is treated as medical treatment. And in a local authority, it concerned a 29-year-old lady. She had 2 previous children, both of whom had been removed at birth and adopted. She, at the time, didn't want to have any more children and was having a depot injection as contraception. She then marries a chap who's known in the decision as Mr. A, and after that decides to refuse to have her depot injection. She was attending college. She began to report domestic abuse at home, and then began reporting that she thought she might be pregnant. So the college took her to the family planning clinic, confirmed that she wasn't pregnant, but the LA safeguarding processes were triggered because of the domestic abuse at home, and the local authority issued Section 16 proceedings concerning her residence and care. But the decision of a local authority in A concerns an interim application within those proceedings for an interim declaration that P lacked capacity to decide whether to use contraception, and that it would be in her best interests to be required to receive it. So the court looked at this and was invited to set out the test for determining whether a woman had capacity to make decisions to decide to have contraception. And as I say, the first thing the court confirmed was that contraception and requiring someone to take it should be treated like any other medical decision, and went on to set out various pieces of relevant information to make that decision. So the reason for contraception and what it does, including the fact that pregnancy is likely to occur if it's not used, the various types of contraception available and how they're used, the advantages and disadvantages of each type, the side effects of each type and how they can be dealt with, how easy it is to change contraception, and the generally accepted medical effectiveness of each option. What was not relevant was the understanding that someone needed to have to bring up a child. And I think that's a really interesting point, because certainly as someone, if you have capacity, I would have thought, Nicola, I don't know from a psychiatric perspective whether you would agree with this or not, but actually you would want to know what the process of bringing up a child is when you decide whether or not you want to take steps to stop yourself having one.
I'm going to refer back to everybody being human. I don't think you can meet anybody who's not had a child who could properly understand the effects of having a child in your life, a well one or an ill one, or anything in between. I think it's one of these, it's almost a philosophical problem of capacity. I don't think anyone can really understand what it's like until they do it.
That's interesting. It's a fair point. One of the other areas that crops up in obstetric decision making in the COP is the issue of abortion. And it's a legally interesting one because there are various statutory schemes that apply. So you need to bear in mind Article 8 of the ECHR, and that comes from the case of Evans in the United Kingdom, which confirmed that Article 8 includes respect for decisions to become or not become a parent. So Article 8 bites in abortion decision making. And of course, we also have a specific act regulating abortions, the Abortion Act 1967, in particular Section 1, that confirms the circumstances in which a lawful abortion can be carried out. So when we're making decisions on behalf of people who lack capacity concerning abortions, you have the Mental Capacity Act playing its role, but of course you also need to make sure that the abortion that is being sought is lawful within the meaning of the Abortion Act, as well as in line with the person's Article 8 rights. That being said, the court's view is slightly different. It says that abortion is not a complex issue, and that was the case of Re SB. And one thing that has been considered is whether or not the father of the child should be a party to proceedings. Now, this is an interesting, I think, ethical question, because the Court of Protection's view in the two cases it's been considered, Re SB and Re CS, is that the father must be a party to proceedings. And in those cases, the father was added to a party. But again, whilst I can understand why that is appropriate, I think it sets a different standard for someone lacking capacity in comparison to someone who has capacity, because of course there, if you're a young lady who's considering an abortion, it would be entirely up to you if you involved the father in that decision. There are also various, obviously, pieces of relevant information that need to be considered. They come from the cases of S in Birmingham and Re CS. So S in Birmingham confirms that the relevant information is what the procedure involves, the effect and risks of the procedure, and the possibility of safeguarding measures for the baby if it's given birth to. And that was slightly expanded upon in Re CS, which considered that the relevant information also included options for termination, the extent of the person's pregnancy. So that would accord with making a lawful decision in line with the Abortion Act, previous views about pregnancy, so wishes and feelings, their personal circumstances and their ability to care for existing children. That being said, Nicola, I'm going to turn back to you to talk about something that does routinely crop up that is really difficult to deal with, which is what happens when P refuses to take part in a capacity assessment.
Yes, one of the gloriousness of being a clinician is the patients interrupt their best laid plans every day. And when we were talking, Matthew, before this, you and I were thinking about some of the most difficult decisions is not deciding whether somebody has capacity or doesn't have capacity when they're speaking to you. It's when people refuse to engage at all. And while it's very easy to fall back on the Capacity Act, say we must assume capacity, it's actually quite difficult if that person has told you or told somebody that they've taken a large overdose and they're about to go into liver failure, or they've taken some antifreeze, which is a relatively uncommon way of harming oneself, which requires antidotes and often ITU, and that there's a time critical period to deliver those episodes of care. And so one of the questions is, why wouldn't somebody, if they were able to engage, because we're not talking about people who are so confused or delirious or suffering from dementia that they're unable to engage in it, but why would somebody refuse to engage in a capacity assessment? And I think there's lots of answers to that, as many as there are people on the planet. But I recall a young woman that I saw who actually seemed to engage in a capacity assessment. She had been told by surgeons that she was going to perforate her bowel within the next 2 or 3 days. It was 5 o'clock on a Friday, classically, so they said that you will perforate your bowel over the weekend because of this inflammatory bowel disease that you suffer from, and that would likely lead to her death. If your bowel perforates, they have overwhelming infection. She was already immunocompromised, that would lead to her death. And she listened to us, give her all the information about the risks and benefits of bowel surgery, and then she said, no, I don't want it. And when we said, okay, can you tell us why? She said, no, I don't have to. And she referenced the Mental Capacity Act, which she knew what we were testing it against. And so we spoke to the legal team, and we all decided together, surgeons with support from psychiatrists, that we thought she probably did have capacity, and she survived. 10 years later, she's still alive. And so it was a salutary lesson, and no matter how certain we are that we can predict the future, sometimes we still can't. Back to the beginning, not even surgeons can predict the future, it's not just psychiatrists. And when I wondered why she didn't want to tell us what the reasoning was, I think she was really angry. I think she was angry that she had this diagnosis, that she was this ill. She was angry with us for not being able to cure it. She was angry with her family for a whole variety of different things. She was really angry, and anger and punishment is something that I think often comes to the fore when people decline to take part in the capacity assessment. I'm thinking about another patient who would take something which required an antidote, but she wouldn't talk to us to let us give her the antidote. And I think it was a way of punishing her family, of keeping them questioning, is she going to survive this time? It was really quite punitive. And sometimes we have patients, and I'm thinking about a particular diagnosis, who refuse to engage in capacity assessments after an episode of self-harm because they're trying to force us to take responsibility for them. They're trying to force us to say, I don't think you have capacity, I'm going to enforce treatment, I'll restrain you, I'll give you the antidote, I'll do all of these things. And the particular diagnosis I'm thinking about is what used to be called emotional unstable personality disorder. And we know that trying to take responsibility from those people is actually quite damaging in the long term. So psychiatrists find themselves, and this is something that psychiatry can make a comment about capacity, but we find ourselves in this really awful balance where somebody's done something to themselves out of terror or fear or emotional dysregulation, and we can fix it, but they are forcing us to force them to fix it rather than wanting it themselves. And there's lots of complex dynamics that might be going on there, and very little of it will be apparent to the patient. I don't think they're sitting there sort of plotting against us, but we find ourselves in the situations where we say, I don't know if you've got capacity or not, but I'm going to err on the side that you do actually, and I'm going to try to have this consultation in such a way that you choose to save your life, that you take responsibility for letting us save your life, for letting us treat you, rather than us taking responsibility for it, because in the long term, that's not going to be helpful for you. We want you to engage with us in a therapeutic way. And that can be quite frightening, because it sounds like from the outside that somebody's saying, I've just tried to kill myself and I might be dying. And we're going, well, we hope not, but we'll be here if you choose to come back and take the medicine. We'll be here if you choose to come back and accept the treatment. And it's enormously difficult to walk that balance, thinking about the short-term saving life and the long-term impact on our therapeutic engagement. And of course, there is another small subgroup of people who tell us that they've taken something or that they've done something and actually haven't, again, trying to force us into taking responsibility and delivering care from them, which isn't as a result of a personality disorder or a psychosis or a neurosis or an affective disorder, but as a result of factitious disorder, where they take a series of actions consciously to elicit care from the medical profession. And that's fascinating to be part of as well, because sometimes they might harm themselves trying to elicit this care from us, which of course we're happy to give. And sometimes they might not have harmed themselves, but tell us they have done to elicit the same care. And so as well as dealing with the difficulty, the physical problem with the patient in front of us, again, we're trying to think about long term. What is it that this person's gaining from this? Is there anything we can do to change it, to make it safer, to reduce the risks of the iatrogenic harm that's done by us? And how do we manage all of the other situations around it? How do we manage the clinicians that are involved in this care so that we allow them to be as kind and as compassionate as they want to be? Fascinating different parts of problems with capacity and engagement. Wonderful.
It is interesting. And I think, looking at the time, we should, I'll leave the last slide. People can look at that in their own time. It just talks about and gives various references for obstetric care and the difference of treatment in the MHA and MCA.
Thank you all very much indeed from your various specialisms and geographic locations for attending today. And at 1:03, can I wish you all a very good afternoon. Thank you very much.